All right, please have a seat. All right, the next case on the docket is, and I apologize if I mispronounce it, NICARRY versus ESLINGER. Okay, would you like any time for rebuttal?
Could I reserve 5 minutes for rebuttal, Your Honor?
Absolutely.
Thank you, Your Honors. Good morning. My name is Randy Schimmelpfennig. I represent NEAL NICARRY in this action. He's the appellant. It appears to be a case of first impression in the state of Florida, and it deals with the interpretation of Florida Statute Section 95.115G. And the issue here is whether a prisoner who files a complaint based on a one-time event of alleged negligence is controlled by whether that action is barred or controlled by that one-year statute of limitations contained in that statute, which deals with actions brought by prisoners relating to the conditions of their confinement.
And why wouldn't McCarthy and the other cases of the United States Supreme Court be instructive on that issue?
They might be instructive on the issue, but they're not controlling, Your Honor, because none of the cases that's been cited by either party in their briefs deal with the issue of the statute of limitation. McCarthy dealt with an assignment of a case brought by a prisoner to a magistrate as opposed to barring the case by the statute of limitations. So it's kind of apples and oranges, and nothing has really dealt with this issue of the statute of limitations on a prisoner's suit like we have here in the state of Florida. All of these cases use this term conditions of confinement, but they're used in all kinds of different contexts. So when you talk about a statute of limitation, that's a very onerous effect on a client because...
But the Supreme Court was interpreting a federal statute that, even though it wasn't the statute of limitations, dealt with prisoner suits differently. Correct?
Yes, sir.
And this is a statute of limitations that deals with prisoner suits differently by setting a shorter statute of limitations. So I guess my question is the same. I mean, why wouldn't the interpretation... I mean, they give policy reasons that are related to the policy reasons that the Florida legislature set forth in enacting this statute that seems similar. Why wouldn't that same interpretation be...
The way I read the Prizer and the McCarthy cases is that they're dealing with a dichotomy that's set up by the federal statutes that deals with two types of cases. There's why the fact of imprisonment, I think they call it, and then the conditions of confinement. So you're either in one basket or you're in the other. This is a totally different situation where it involves a one-time tort, and it doesn't involve why this man's in jail, or it doesn't involve why the conditions of his confinement. In a prisoner suit, like how hard the beds are, the food's inedible, that sort of thing. If I could give you a couple of analogies here, if Mr. NICARRY had been in a totally different situation, if he had been in his apartment, say, and had been exposed to these toxic fumes, he was exposed to some welding fumes here, there'd be clearly a 4-year statute of limitations.
Let me give you some. What if there was a welding class right next to the prison and there were some cells that constantly got the fumes from that welding facility, welding class, whatever? Would that be a condition of confinement?
Yes, I believe that would be a condition of confinement, because that is something that's an ongoing situation where it's a chronic buildup of the welding fumes. And I think there was one of the...
What if the inmate was only in the cell for one day?
Well, I think that would
transfer bonded out?
That would still be conditions of confinement, though. It wouldn't be the one-time event like we're dealing with here. Here, Mr.
It was a one-time event vis-a-vis that individual.
Would that make logical sense to say that under this circumstance where the prisoner is exposed to toxic fumes for one day, it's 1 year statute of limitations? But I mean, that dichotomy that you're arguing for, the line doesn't make sense really.
But if there's the ongoing welding classes in the building next door, and the conditions of the confinement are that he's put in this cell where these welding fumes are always coming over, I think that's a conditions of confinement. That's an ongoing event.
What if they're doing repairs to cells nearby for a month?
I'm sorry, here.
What if they're repairing cells nearby and have welding going on for a month?
I still think that's a conditions of confinement type situation.
10 days?
Well, where you draw the line is difficult, and hard facts make hard cases.
And is the line drawn at a one-time occurrence versus two?
Yes, I believe it would be. Because conditions is plural. And conditions is the dictionary quote that I put in my brief is ongoing conditions, ongoing circumstances. So what we have here is a one-time event where this man was exposed to these welding fumes and he was injured as a result of that one-time exposure. Now, if you're talking about multiple or ongoing conditions, then that's a conditions of confinement case where the 1-year statute applies.
So if they came back a second day to finish whatever they were doing with the welding, then that would be a 1-year statute of limitations, but because it was a one-day job, it's a 4-year statute of limitations. That's your argument?
I think you're getting there closer to the conditions of confinement than you are with just a one-time exposure like we had in this case.
And if someone is mistreated by a guard one time, is that a conditions of...
No, when you're talking about the actions of the guard and actually mistreating him, then you get into the Eighth Amendment and civil rights and that sort of thing, and that is the analysis used by a lot of these federal cases. But this is a pure negligence case. And so I think that a one-time mistreatment by a guard would be in a different category. And I don't
would it be a condition of confinement under this statute?
I don't think mistreatment by a guard would be a condition of confinement. I think that deals with your ongoing prisoner suits that you probably...
What if it's an ongoing systemic problem at the institution? The guards are abusing prisoners regularly. Would that be a condition of confinement under this statute?
That would be conditions of confinement. Anything that's ongoing.
What if they served jalapeno peppers and the prisoner came down with Seminole poisoning and had some significant reaction and problem? What's the statute of limitations? One-time event.
I think that would be 4 years because that's a one-time negligent event. That's not an ongoing condition. This is something that's happened in one instance that caused this person damage. It'd be like if he's out in the work yard, a car runs off the road, runs through the fence and hits him in the work yard. I don't think anybody would argue that that's a 1-year statute of limitations because even though it has to do with the fact that he is in jail and it was injured while he was in jail. That's not a condition of confinement.
How do you deal with the other side's argument that the interpretation you're arguing for would obviously, it appears to me, increase litigation over what the statute of limitation period is, given the kind of line drawing that's going to happen on a case-by-case basis, when the legislative intent in passing the shorter statute of limitations was to, they said, reduce litigation.
And the term that they use frequently in that preamble to the legislation is that they wanted to get rid of frivolous lawsuits. And like I was saying, your bread's moldy or the bugs in the mattresses, that sort of thing that are more of an ongoing thing where they have noticed that they need to be getting on with these and have a shortened period of time. But there's no reason in this case why Mr. NICARRY should be differently situated than anybody else in the state of Florida for bringing a negligence action just because he's a prisoner and just because he was exposed to these fumes in the prison. I think that's a 4-year statute should apply to that. The fact that he was in jail was simply the situs for where this negligence happened. It had nothing to do really with the fact that he was a prisoner. And I think that just because it's a one-time event, that is a case where there should be a 4-year statute of limitation.
But if 95.11 gives 2 exceptions for prisoner complaints beyond the 1-year statute of limitations, and this isn't one of them, how do you square your argument with the fact that there are some exceptions that were recognized by the legislature? The
legislature's exceptions are for habeas corpus. I don't recall exactly what the other one was, but the cases deal with the habeas corpus, and there is no statute of limitations for those that should be just barred by latches whenever one of those is raised. But the legislature also put the 4-year statute for negligence actions in that same 95.11. So you have your negligent statute of limitations, which is clearly 4 years in the general sense, and then down to 9511.5G, where you talk about suits by prisoners relating to the conditions of their confinement. I think that's a totally exception to the everything else in that section, 9511. The other argument that we have is that because of the 6-month notice requirement by 768.28, you're in effect limiting this to a 6-month statute of limitations because you have this 6-month notice requirement that you have to give the state. So in this situation, you're not only limiting it from 4 years to 1 year, you're limiting it from 4 years to 6 months, which is, I believe, unfair, and there's really no rational basis for that. I have nothing further, Your Honor. Thank you very much.
Thank you.
May it please the Court. My name is Tom Polton. I'm here on behalf of Sheriff Esslinger. I'd like to begin by just noting that an observation about the hypotheticals that you were giving opposing counsel. The most important thing about those hypotheticals is that they demonstrate that there could be reasonable differences of opinion as to what the phrase conditions of confinement means. The fact that there are hypotheticals that could be posed in that manner that would create the question of, well, are we talking about an ongoing condition with a one-time exposure, or are we talking about multiple incidents, multiple injuries, and the fact that if you have a situation where you have multiple injuries, that would give you a shorter statute of limitations, actually, under plaintiff's interpretation than if you just had a one-time exposure. That demonstrates that, in fact, we can't just rely on what might be the more natural reading, as the Supreme Court said in McCarthy. We can't just rely on that. We have to go into the rules of statutory construction and look at the secondary and tertiary sources of persuasion on what the statute means. And, of course, we rely on, first of all, the U.S. Supreme Court decisions, McCarthy, and actually Porter versus Nussel, which extended this notion from the Magistrate Act in the McCarthy decision and said we don't want to make a dichotomy here between a single incident versus a chronic ongoing situation. They extended that to the exhaustion of administrative remedies in the Prison Litigation Reform Act. And I would note that in the Senate bill analysis, the Prison Litigation Reform Act, the federal statute, is cited quite a bit by the Florida legislature in their effort to curb the number of inmate lawsuits. I would agree with counsel that you can make an argument to parse between types of lawsuits. For example, as he points out, bed bugs or bad food, things like that, versus an inmate being attacked by corrections deputies. The problem is there's no way to parse that out in terms of the legislature, and they chose to adopt the 1-year statute of limitations, and they chose to make it applicable to all conditions of prisoners' confinement. Your Honor, you asked counsel about the exceptions that were in the statute. The exceptions being a petition that challenges the criminal conviction, or maybe one for an extraordinary writ. And what I would submit, Your Honor, is that it's pretty clear the legislature is trying to divide between basically tort claims versus claims that have to do with the criminal conviction. And, of course, this is a tort claim and would fall squarely into our interpretation of the statute, should you find that to be the reasonable one. As I understand it, if the statute were capable, and there were no debate, of just one interpretation, then we might lose. But because it is subject to multiple interpretations, and you would look at these additional sources, I have to say all of the authority that I think has been presented to you is in favor of the sheriff's position in this case. You've got the U.S. Supreme Court decisions, the one interpreting the U.S. Magistrate Act, and then the Porter case, which interprets the Prison Litigation Reform Act. Granted, they're not statute of limitations cases, but they are dealing with the very same argument that the plaintiff makes here, which is that, well, we should limit this to just situations where it's a chronic ongoing condition rather than one which is limited to a single incident. The second point that I wanted to make on that was that the fact that there are these hypotheticals, Your Honor, this picks up on the point that I believe you were making, would increase litigation if, in fact, the circuit courts had to distinguish between, well, is this a situation like in the example of the welding class next door, is that a condition which results in a singular injury? So is that a condition of confinement, or is that going to be the single incident case where you're going to have a 4-year statute of limitations? And it'll just create more litigation over those issues. The broader reading gives everybody instruction that, in fact, this refers to basically all tort claims that would be brought by people who fit the definition of prisoners. And along those lines, Your Honors, I would point out that
Counsel gave the hypothetical where, and if I paraphrase it a little bit, that the prisoner's out in a yard exercising, and a vehicle comes and loses control, goes through the fence and hits the prisoner. What's the statute of limitations on that?
1 year. My answer to all of your hypotheticals for a tort claim is going to be 1 year. And the reason is that gives everybody instruction that it's a clear line, gives the court the benefit of reducing inmate lawsuits, and it also gives the circuit courts the ability to say it's a tort claim, you fit the definition of a prisoner, you've got 1 year. The point I was going to make, Your Honor, is
the person that's driving the car is completely unrelated to the prisoner.
If I would submit, Your Honor, that if it happens within the context of the jail in this case, or a prison, that it would be 1 year, because the person is injured by virtue of being an inmate. They're struck, whether the car comes from a corrections deputy or from somebody who's just happened to be driving down the road, they're still struck as an inmate. I mean, that's what led them to be in that situation to begin with. And that's the purpose of the legislation, is to reduce inmate litigation. The subtext of plaintiff's argument is that this is not fair to inmates, and I submit that that's just not a valid consideration in this case. The legislature has made the determination it wants to reduce inmate lawsuits. You may be able to find individual ones, like that scenario where you say, well, that doesn't seem right, or in plaintiff's view, his situation, he shouldn't be subject to a 1 year statute of limitations. You may be able to find individual ones that you don't feel like that's justified to limit their right to recovery to 1 year, but the legislature has made the determination that it wants to do that in order to reduce inmate litigation. And the problem is that if you start parsing out these individual circumstances and say that one should be covered and that one shouldn't be covered.
I know the issue isn't really raised here, so maybe I shouldn't ask, but I am. Do you see any kind of access to court or other constitutional problem with the combination of a 1 year statute of limitation and a 6-month notice requirement?
No, Your Honor, and the reason is that as I understand the case law, and I believe we cited some in our brief, that if you file your lawsuit prematurely while the 6 months is still, let's say you do your notice of claim under 768-28-6A, and you file your lawsuit the day after that, the trial court can simply abate your action until the 6 months is expired. So somebody might misread that to understand that, well, I've got to do my notice of claim and then I'll have a 6-month window at the end of that. That's possible that somebody would misread it that way, but in actuality, in operation, they can file the day after that. They just can't proceed with the litigation until the 6 months is expired or the claim is rejected, whichever happens first. Your Honors, at the end of the day, I think it's a pretty simple appeal in the sense that if you decide that the statute is capable of only one interpretation, what you might call, or the U.S. Supreme Court might call, the more natural interpretation, then reversal is mandatory. But if you decide, well, this statute is capable of different interpretations, let's look behind the scenes. Let's look at the analysis for Senate Bill 8. Let's look at the U.S. Supreme Court or other federal decisions which are interpreting similar federal statutes. Because that's all we have to go on right now, then the decision of the circuit court's due to be affirmed. Unless anybody has any other questions.